Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, if you're enjoying our legal education content, please remember to subscribe and hit the notification bell. It helps the channel grow. For today's situation, we're dealing with the Second Amendment and Missouri's passage of the Second Amendment Preservation Act. In this situation, the Department of Justice sent a letter, and they are salty. And Missouri sent a letter back because they don't care. So we're going to do this as a Part A and a Part B. Today's story will be Part A. What the U.S. Department of Justice said about how they're super sad about this thing that Missouri passed, the Second Amendment Protection Act. Why are they sad? What legal things do they have to say? Does any of this make any sense? Let's get started with this. Dear Governor Parson and Attorney General Schmidt, I write regarding Missouri House Bill number 85, which was signed into law. By terms, the statute appears to declare numerous federal firearms laws to constitute infringement of state and federal constitutional rights, to prohibit all persons from enforcing such laws in Missouri, to preclude Missouri law enforcement agencies from participating in enforcement of such laws, and to prohibit Missouri law enforcement agencies from hiring any former federal law enforcement officer or agent who enforce the law or provide support for enforcement. And right away, I'm like, ha, sucks to be you, DOJ. All right, so let's just start with Basic Principles 101. All right, we live in a federal republic. We are a collection of independent states that are in a collective federation. Now, our situation is a little bit weird because of the nature of our relationship, right? The states are sovereign. Individually, they're sovereign. And the national government is also sovereign simultaneously. That's the nature of our system. The states can do stuff. The federal government can also do stuff. Generally speaking, the federal government's role is more external focused. International trade, international relations, military, diplomacy, right? So if you're thinking, what does the federal government do? Generally speaking, how about relationships with other countries? War or peace? Or they deal with the Indian tribes too. That's basically what they do with their time. In general. The states, however, more domestically focused, right? They are more focused on what happens within the confines of the United States, less so with the federal government, generally speaking. So that's the situation number one. Then we have this thing called the non-commandeer doctrine. All right, what is that, you ask? I'm so glad you asked. There is a case called Prince versus United States, which basically stands for the proposition the federal government cannot commandeer or take control of the state level authority. So if the federal government wants to pass a law, any law at all, they can pass a law and they can come up with their own enforcement mechanisms to enforce it. They can come up with their own police. They can come up with their own prison systems, their own systems of justice, whatever. And they can go forth into the world and they can do what they can do. But what they can't do is they can't make the state do their bidding. They can't make states pass laws. They can't make state law enforcement agencies, do particular things. They can't commandeer the apparatuses of state level authority. All right, unless there is some specific constitutional provision that applies, which is the other big exception. So there are, of course, exceptions to the rule, but to look for the exceptions, you have to look for specific authority, right? So as a general proposition, if the federal government wants the state to do something, the state can tell them to go to hell. And that's largely what Missouri has done. Missouri has said, our state law enforcement agencies are prohibited from enforcing these laws. They are prohibited from helping you or cooperating with you to enforce these laws. And also, they're prohibited from hiring you guys. Can Missouri do that? Yep. No problem. That's perfectly fine. You want to have your own mechanism, go nuts. We're not going to help. Yeah. The public safety of the people of the United States and citizens of Missouri is paramount. We are concerned that absent clarification, HB 85 threatens to imperil the long-standing and close cooperation between federal government and law enforcement agencies in Missouri that seek to jointly combat violent crime in the state. It may very well imperil the long-standing and close cooperation because Missouri doesn't want to so much with the close cooperation anymore. They'd like to very specifically not closely cooperate. Yeah. At a time when homicides have increased in Missouri, and neighboring states measure the impact, the effective enforcement of federal law will increase the risk of violent crime in our communities. if you want to enforce federal law, go nuts. Just don't ask us. Existing federal laws and regulations relating to firearms, which are consistent with the Second Amendment, are an important check to keep firearms out of the hands of criminal. Well, if it's that important to you, you can do it. As explained below, numerous provisions of HB 85 raise significant federal law enforcement and legal concerns. Do they, though? In light of the significant public safety risk the law presents, the Department of Justice respectfully requests you take action to clarify and respond to a letter. They did respond to a letter. We're going to do with that in Part B. But let's read more about what the Department of Justice has to say. HB 85 includes a number of provisions that raise concerns. The law states that federal acts, laws, executive orders, administrative orders, rules, and regulations falling into 5 categories of regulations related to firearms shall be considered infringements of the people's right to keep and bear arms as guaranteed by the Second Amendment of the Constitution and our Constitution. As far as we're concerned, sure, these infringements, and also incidentally, they're a violation of both our Amendment 2 and our Constitution. Can a state declare that certain things are just arbitrarily a violation of the federal Constitution? They're pushing their luck. But can they arbitrarily declare things to be a violation of their own Constitution? Sure. Why not? It's their Constitution. So, yeah. Here are the things that we now consider to be unconstitutional under our Constitution. Any tax, levy, fee, or stamp imposed on firearms or ammunition not common to all other goods. So as long as it's a common tax, yes. If it's a non-common tax, no. Any registration or tracking of firearms, accessories, or ammunition. Any registration or tracking of ownership of firearms, accessory, and ammunition. Any act forbidding the prohibition, ownership, use of firearms, or accessories, or ammunition by law-abiding citizens. Any act ordering confiscation of firearms. We consider it to be a violation of our state constitution, no problem. HB 85 further provides that any such purported infringements shall be invalid to this state, shall not be recognized by the state, shall be specifically rejected by a state, and shall not be enforced by the state. I see no problem with this. I see no problem with any of this because the state can say, okay, it's invalid as far as we're concerned. If you want to come enforce it, federal government, we can't stop you as much as we'd like to. But we don't have to help. We can declare it a violation of our law. And since you can't commandeer our people and our law, don't ask for us for help. So, it sounds okay to me. The law provides that no entity or person, including any public officer or employee of the state, or any political subdivision of the state, think counties and cities, shall have authority to enforce or attempt to enforce any federal law, executive order, administrative order, rule, regulation, statute, ordinance infringing on the right to keep and bear arms. As far as we're concerned, you may not enforce any federal law. Can a state do that? Yep. No problem. No problem. You can't commandeer state-level authority. We think your law is illegal. We are not going to help you enforce it. To everyone under our control, you are forbidden from helping. We consider it a violation of the law. You may not assist. Sounds okay to me. Yeah. The state also imposes limits on law enforcement officers who can be employed by Missouri governmental agencies. The law provides civil penalties for $50,000 per occurrence against a political subdivision or law enforcement agencies that employ a law enforcement officer who knowingly violates the law. So, don't employ any officers who knowingly violate our state law. It's our state law. You can't employ them, state agency / county agency / city agency / whatever. This is again the superiority of the state level government. Right? The federal government is sovereign. The state government is sovereign. The cities and counties are distinctly not sovereign in any sense. The law allows, and the states can have any relationship they want by terms of their own constitution. So some states restrict themselves more than they strictly speaking have to by their own constitution because they can. Right? They can impose limits on themselves. So some states by their own constitution give more authorities to counties or more authorities to cities or whatever. That's fine. That's a choice you can make. You know what choice you can also make? The exact opposite of that. Because ultimately, the state can say, all the cities and counties, you will bend to our will. You are but creatures of the state. We can abolish your existence. You exist as cities and counties at our pleasure. And we can just obliterate your existence from the map if we want. It's nice, right? It's like, yeah, we're sovereign, and you're political subdivisions. You will bow to our absolute will. Yeah, that's what we call the police power. To use the proper term of police power is the general power to do stuff, not to be confused with police forces, but the police power. The police power is the general power to do stuff in general. The states have police power. The general power to do stuff. What kind of stuff? Overtake any apparatus within the state authority or political subdivisions or anything they want, basically. Yeah. The law also imposes similar penalties on any political subdivision or law enforcement agency that knowingly employs an individual acting or previously acted as an official, agent, employee, or deputy of the government of the United States, or otherwise acted as color of law on federal law within the borders of the state who has enforced whatever. We consider you to have done a bad thing. We don't want to hire you as police within our jurisdiction. We don't have to hire you. FBI agent, you are not a protected class. The law appears to materially limit the cooperation of state officials or others in federal prosecutions insofar as only certain specified federal prosecutions are identified a purported safe harbor. Yeah. Yeah, I mean, you can't stop the federal government from prosecuting people federally, but you don't have to help. You don't have to help the DOJ or the U.S. Attorney or the FBI or Homeland Security or anyone else. I can't stop you. I can't interfere. I don't have to help. HB 85 threatens to immediately disrupt the working relationship between federal and state law enforcement officers, many of whom work shoulder to shoulder on various task forces. Yes, it does. Your point being what? For which Missouri receives ample federal grants and other technical assistance. Missouri doesn't want those things now, apparently. Missouri has apparently decided in their wisdom, we don't really want the federal grants and the technical assistance that much. We think the Second Amendment's too important for that. Your bribery is no longer working. We don't want to go along with this deal anymore. In addition to licensees who are obligated under criminal penalty to comply with federal law, and Missouri citizens. Okay, yes, that's true. Because the federal government can't commandeer the state apparatuses. It can make laws that apply to people, just not states. Right? So can the federal government have FFLs? Sure, why not? It doesn't require the state to do anything. Right? It's like, well, if you want to sell a gun in interstate commerce, thank you, Wickard v. Filburn, you have to have an FFL. I know some exceptions apply. We're just talking in general. Can they do that? Sure. Yeah, unfortunately, Wickard v. Filburn and a whole bunch of other cases, sure. So, yes, the FFLs and licensees and the Missouri citizens are obligated to comply with federal law. Correct. But the state enforcement mechanisms are none of those things. As drafted, HB 85 raises significant concerns under the Supremacy Clause. Does it, though? Let's find out. As an initial matter, Section 1.420, blaze it, raises significant preemption concerns. That provision purports to declare 5 categories of federal arms regulations shall be considered infringement of Missouri's constitutional rights, as well as the Second Amendment. Specifically, this provision purports to declare unlawful federal firearms regulations pertaining to tax and fees, registration, tracking, possession, ownership, use, transfer, and confiscation. Under our federal system, a state cannot nullify federal law. Yeah. Instead, where federal law conflicts with state law is preempted. Well, that's kind of true. I mean, the federal government has to have the authority to do it. So, yeah, and there's certain federal laws that can't exist. For example, the preemption laws I've been talking about most of this time. So, yeah. The Supremacy Clause provides that laws of the United States shall be supreme, anything in Constitution or law of the state notwithstanding. Pursuant to supremacy, the federal law preempts state laws, where, among other things, state laws interfere with or are contrary to federal law. We're not trying to interfere with federal law. We don't care, nor can we care. Conflict of preemption occurs when a state law actually conflicts with federal law, where compliance with both federal and state law is physically impossible. There's nothing that prevents anyone from complying with both federal and state law. The Missouri is not trying to prevent the FFLs or, the citizens of the state from complying. They're simply saying the state is not going to comply, which, again, because of preemption, they don't have to do. So I don't see any conflict. Section 1.420, Blaze It, declares that 5 categories of federal firearm regulations are unlawful, but the Missouri statute makes no effort to establish that 5 categories of federal violations violate the Second Amendment. Yeah, you probably can't arbitrarily declare that that probably is a step too much to declare that they violate the Second Amendment, because you can't do that because it's a federal law. But you can definitely say it violates this, and you can definitely say it violates the, and we can also say it's our view it infringes, which governments do all the time, right? They usually do it in the form of amicus briefs, but it's definitely not unheard of for a state to write the U.S. Supreme Court as an amici and say, hey, U.S. Supreme Court, we think the federal government law is illegal. We think that they've got it wrong. So a state can declare as a matter of state policy, we think that you get it wrong. As long as they're not preventing the federal government from doing anything, that probably works. How's it fundamentally different than an amici letter? I don't know. The Supreme Court in District of Columbia said that most rights, the right secured by Second Amendment, is not unlimited. And examples of presumptively lawful measures consistent with the right, including long-standing prohibitions on possession of firearms by felons and the mentally ill, or laws prohibiting firearms in sensitive places. Yet Section 1.420 would declare such measures to constitute federal acts, laws, agents that infringe on the people's rights to keep and bear arms. Such a declaration threatens to stand as an obstacle to federal law. How? The new state law tells people in Missouri that federal firearms registration is invalid. As far as they're concerned, yes, it is invalid. The provision also makes it impossible for FFLs to comply both with state and federal law. No, it doesn't. Why would it? For example, does Section 1.420 purport to make it unlawful for an FFL to run a national instant criminal background check before the transfer of a firearm? No, because unless there is a state-level authority that does FFLs for private citizens, which, no. But is there any situation? No, because they're not trying to prevent FFLs. An FFL is just a private person for the vast, vast majority of situations. So is the state of Missouri trying to prevent FFLs from running background checks? No. Doesn't appear to have anything to say about that as far as I can tell. Likewise, does this section also purport to make it unlawful for a state or local police officer to request Bureau of Alcohol, Tobacco, Firearms trace a firearm recovered from a police station? Please request clarification. Well, I don't know if it does or not. But if it does, I mean, they can, right? Is there a federal law that requires them to trace it? And even if it does, it probably can't apply to state officials because of the commandeering thing. So, does the law prohibit a state-level agency from doing a tracing through ATF? Maybe, but even if it does, what's the problem? We're simply telling our agents not to use this resource. They're our agents. Although Section 1.4204 is limited to possession, ownership, use, and transfer restrictions on law-abiding citizens, that does not appear to shield this part of the statute. Section 1.480 defines law-abiding citizen as a person who is not otherwise precluded under state law from possessing a firearm. Well, yeah, because we have the ability to determine what we think a law-abiding citizen is for the purposes of our citizens. They are our citizens. It is correct. It is correct to say that people living in Missouri are citizens of Missouri. It's in the 14th Amendment. It's in the 14th Amendment. You're a citizen of the state. You're a citizen of the state in which you reside. It is correct. It is correct to say that a person is a citizen of the United States and a citizen of the state in which they reside. For example, yours truly, as the flag on the wall might show you, I am a citizen of Texas. The 14th Amendment says that. That is not a radical proposition. It's in the Constitution. So can they determine what a law-abiding citizen of Missouri is? Of course they can. It's their citizens. Federal law presently includes prohibitions on possession of firearms not reflected in Missouri law. Okay. The federal government considers those people to not be law-abiding under federal citizenship rules. We consider them to be law-abiding under our Constitution. They're law-abiding as far as we're concerned. Don't know what you think, but we think they're law-abiding. There are citizens too. By its terms, Section 1.450 provides that no entity or person shall have authority to attempt or enforce the enforcement of any federal law, blah, 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 that infringes on the right to keep and bear arms. If this section were construed to apply to federal officers in Missouri, then that would violate the doctrine of intergovernmental immunity, which prohibits states from regulating the federal government. That's true. That is absolutely correct. That is 100% absolutely correct. Missouri cannot, through its law, prohibit a federal official from enforcing the federal law in the course of their duties, while they're executing those duties. So if the law, as written, is understood or would understand to try to prevent federal officials in any sense by taxing them, by whatever, right, then that would be invalid. We can't interfere with the federal government. We don't have to help, but we can't interfere. So, yeah, if that's the way the law reads, then Missouri would have a massive problem. Right. The activities of federal government are free from regulation of the state. Correct. The states have no power to impede the operation of constitutional laws enacted by the Congress. Correct. We assume Missouri does not intend to directly regulate federal law enforcement agencies, and instead imposes limits on state law enforcement. If that's correct, then that's fine. Missouri cannot directly regulate federal law enforcement. It can impose limits on state law enforcement. We also assume Missouri does not intend this to limit enforcement of federal law to prevent private persons and entities from complying with federal law. Also correct, right? The federal government can regulate its citizens and the people within its territory. So Missouri law cannot prohibit a person, individual person, a private person, cannot prohibit a private person from complying with the federal law. So if the Missouri law said, oh, we're going to prohibit the FFL, that's not going to fly. Yeah. The persons subject to 1.50 include any police, public officer, or employee of this state or any political subdivision of this state. This provision accordingly could be interpreted to extend only to Missouri state and local officers as well as state and local agencies. That does seem to be the most natural reading. Section 1.50 says the person subject to it include any public officer or employee of this state or any political subdivision of this state. This could be interpreted to extend to only Missouri state and local officials. As opposed to what? I mean, yeah, any officer of this state or political subdivision. Yeah. Section 1.460 imposes a liability on any political subdivision or law enforcement agency that employs a law enforcement officer who acts knowingly in violation of the law. Okay. Knowingly attempts to enforce the law. Section 1.460 thus imposes liability on any Missouri agency that employs a law enforcement officer who participates in any joint operation with federal law enforcement to enforce federal firearms law outside of very narrow exceptions. Correct. You are correct, sir. You are correct, sir. You have properly understood our statutes, sir. Yes, we are imposing liability on any political subdivision, police force, police agency, state agency, whatever, from employing any person who helps to enforce the law. This would impact, for example, working with federal law enforcement on a joint task force. Correct. You are correct, sir. We are no longer going to let them participate in those joint task force. Yes. Okay, and therefore what? A limitation of this kind raises substantial law enforcement concerns. The United States deeply values its partnerships it has formed with these states to keep our community states. I'm super thrilled for you that you value them and all. That's super interesting and all that you value them, but we're just not that into you right now. I think we're best off as friends. Enforcing federal law enforcement is part of these efforts. Without this kind of federal-state cooperation that has benefited us all, our collective enforcement efforts will be impaired. To the extent it's not intended to impair, we ask for your clarification. It's very, 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 very much intended to impair. You were correct the first time. Section 1.470 would impose a significant liability of $50,000 on any state or local agency that employs an individual who previously worked for the federal government or acted in cooperation with the federal government in Missouri and who enforced or attempted to enforce federal firearms laws falling within this section or who gave material aid or support to someone who did. On its face, the provision therefore appears to discriminate against federal law enforcement officers. Yep. And others who worked with them. Correct. Such as state and local law enforcement officers who served on a joint task force. Yes. Correct. This kind of targeting of former federal officials and individuals who were cooperating with the federal government may well raise unprecedented and raise a significant concurrence under intergovernmental immunity doctrine. No, I don't think so. I don't think so. You are definitely immune. You're definitely immune from us finding you or arresting you or prohibiting you or whatever. We can't do that. But does it prohibit us from going to the individual? Because if you're getting a job with us, you'd no longer be a federal official, would you? Right? So you don't have intergovernmental immunity when you're not part of the government. Right? You have immunity when you're part of the government, and you don't have immunity when you're not part of the government. Your immunity ceases to be. Now, we can't go backwards and get, things that you did now that your immunity has lapsed, right? So we can't go back in time. You were immune, and you will always be immune for those time periods, right? You are and will always be immune for those time periods, for the actions you conducted within the scope of your duties. But now you want a job on us. Are we defying intergovernmental immunity? No. We're not trying to prosecute you. We're not trying to fine you. We just don't want to hire you. You have no right to be hired by us. That isn't impacting your immunity. You're as immune as you ever were. We don't want to hire you. Sorry about that and all, but no. This kind of targeting of former federal affiliates may violate intergovernmental immunity. Probably not. State laws are invalid if they regulate the United States directly or discriminate against the federal government or those with whom it deals. Yeah, I don't think so. Section 1.470 also raises serious preemption concerns regarding federal grand juries and prosecutions. How so? It's well established that state laws that conflict with the enforcement of federal grand jury and other subpoenas are preempted by supremacy. Yeah, that's fair. Under Section 1.470, an officer who works on a joint federal task force and testifies before a grand jury at trial could have been deemed to provide material aid and support to the efforts of another who enforces the agency. Well, if they worked on it, yes, for sure. If they're merely a fact witness, then no. If they're merely a fact witness somehow, then no. But if they actually cooperated, then yeah. In light of active investigations and prosecutions of violent criminal activity and ongoing proceedings of federal juries, please confirm immediately that it does not purport to prevent any individual, including state or local officials, from complying with the federal grand jury or other federal subpoenas. That's fair. That's fair enough. Section B of the law states the law shall be in full force and effect upon passage and approval. The law, however, provides that provisions of Section 4110 to 485 shall be applicable to offenses occurring on or after August 28th of 2021. We ask whether you clarify the offenses referred to the violations or underlying criminal offenses, whether actions taken after this date but before can be constitute violations. Given the language of it, we assume no action can violate the law prior to this. Absent clarity, we have concerns that law enforcement could be chilled. So the law goes into immediate effect, but it doesn't apply to any offense that occurred before August 28th. Which presumably gives, people the time to get out of the task force and, unwind relationships and all the rest of it. So, yeah. Under the Supremacy Clause of the United States Constitution, Missouri lacks the authority to nullify federal law. They're not trying to. To shield Missouri business or citizens from breach of federal law. They're not trying to. Or to obstruct and prevent federal officials and officials from carrying out their responsibilities. They're not trying to. Because AB 85 conflicts with federal laws and regulations, federal law supersedes the new statute. All provisions of federal law and their implementing regulations therefore continue to apply. As far as you're concerned, sure. As far as we're concerned, a little bit less so. Federal law enforcement agencies, including the Bureau of Alcohol, Tobacco, Firearms, the Federal Bureau of Investigation, the DEA, United States Marshal Service, and United States Attorney's Office, will continue to exercise their duties to enforce federal law. That's fine. We can't stop you. Go nuts. Given the importance of this matter, we ask for clarifications. Please contact if you wish to discuss further. Signed, Brian Boynton, the Acting Assistant Attorney General. Thus, that brings us to the end of Part A of our discussion of the Second Amendment Preservation Act. In this case, the Department of Justice has some concerns because it might cause Missouri to not want to cooperate with the feds. And Missouri's response, without even reading it, would be, that was kind of the idea, yeah. You want the DEA and FBI and ATF and the U.S. Attorney and the United States Marshals to enforce federal law? Cool. That's fine. We don't want to help. We don't really want all that stuff you used to give us. We're done. So that's Part A. And Part B, we will read the actual response letter because, they burned DOJ alive. But at least for a moment, that brings us to the end of discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.